Welcome to this talk by Safe Harbor Estate Law. I'm Margaret Barrett. I'm the owner and founder of Safe Harbor. And if you're wondering if your plan is going to do everything you want it to do, or if you don't even have a plan, you're in the right place, because we are going to get you started today and educate you so that you can be empowered to make the best decisions for you. So since you are here, it may be, this is this is a lot of our team. And what we do is help families protect what is most important to them. That's what's really behind our motivation for our talk and everything we do today. And having a good up-to-date estate plan is a really important thing to do to protect usually it's your loved ones that's most important to you. And at this time of year, the holidays, it's a great gift to start getting this ball rolling so that you can really not leave a mess behind after you're gone or if you get sick. Okay, I am going to tell you a story from my own life that really brought home for me the importance of estate planning. And it was March 10th, 1997. Back then, the phone rang. It wasn't my cell phone. I had to run downstairs to answer it. It was about 6 a.m. It woke me up. So I thought, it's an emergency. What's the emergency? What's wrong? And who am I going to be worried about? So I ran down, I answered the phone, and I heard my sister-in-law, Barb. Well, Barb was married to my first husband, and we were divorced at that point, Joe and I. But so as soon as I heard Barb's voice at 6 a.m. on a Monday, I knew something happened to Joe, and he was the father of my 2 children. So she said, Margaret, I don't know how to tell you this, but Joe died in a car accident last night. And I was shocked. He was 39. If you've ever gotten a phone call or a knock at the door like this, you know what I mean. I mean, it just knocks the wind out of you and changes your life forever. And that's what happened to our family that morning. So then I just had to pull myself together and go tell my kids. And my daughter was actually awake and heard a little bit. And then I told her, but my son, who was 12, I knew would be a lot harder because, of course, he lived to see his dad and he saw his dad a lot. And so I had to wake him up and tell him. And here's their pictures at that age, Benji and Monica. And, you know, his cry of pain, I will never forget. It was horrible. So moving forward, I walked them through not only the grief, but the estate, right? For the future months and even years. And Joe had an estate plan. He really was ahead of most people. He even had a prenuptial agreement when he got remarried. He had a will. He had trust set up for the kids. But there were 2 big problems. He had his divorce lawyer do his estate planning. And his divorce lawyer made one huge mistake. When they signed the prenup, he didn't have 2 witnesses. He just mailed it to him and said, sign in front of a notary. And that's clearly not correct. So that was a big problem. The other problem is he was going through a second divorce and he hadn't updated his papers for his new situation. As a result, we had 7 years of litigation. It went on for 7 years. My son would say it was his whole growing up from age 12 to graduating from high school. It went even to the Minnesota Supreme Court and involved a bunch of lawyers, hundreds of thousands of dollars, at least $100,000 of legal fees. So that situation really motivated me to help other people avoid that kind of problem, because worse than the money and the hassle, the relationships were so strained, and there's still some that are strained to this day, and understandably so. So it could have been a lot better if Joe had done the smooth sailing system. That's what I developed to help people like you walk through a plan and be educated and empowered to really take care of your loved ones the way you want and keep it up to date also. So if Joe had that, we could have avoided, I think, at least $100,000 in legal fees. There still may have been problems. He was going through a divorce. but definitely a large share of them could have been avoided, and a large share of the heartache. So when we are thinking about why estate planning is important, I want you to think about your family. This is my family. This is my wedding day 3 years ago to John. This is just my side of the family. He has 3 sons and spouses and grandkids, and they're part of my family too. But so when I think about why estate planning is important, it's my family. It's my loved ones. It's who's going to pick up the mess when I'm gone, who's going to be stressed out if I'm sick. And these are the people I want to take care of, especially because it's my job. But really for everybody, it's important. So with a good estate plan, you can preserve family relationships. You can make sure money goes where you want it to go. You can make sure it's handled by the people you want. It saves time, money, and hassle. I would say the average plan probably saves 3 times what it costs. Of course, it depends on the situation, and nobody can put a price tag on peace of mind. And so to ensure the best future for your family and your loved ones, you want both a complete estate plan and an up-to-date estate plan prepared by somebody who has estate planning as a major focus of their practice, like we do. So I can't go through the whole smooth sailing system, obviously, today, but I'm going to get you started. And here's where we're going to go. I want to tell you a little bit about myself. Besides the story with Joe's estate, I have other personal experience. My training and my skills, they fit what I'm doing today. But my personal experience really motivates me and helps my clients relate to me. So we've also dealt with my dad's dementia. He died in January 2019. Now we're supporting my mom in this difficult COVID isolation time. And also, it's not on this slide, but of course, when John and I got remarried, we did a prenuptial agreement and an estate plan. And so we're practicing what I preach, and I'm understanding the importance of protecting our family, especially a blended family. So if you're in any of these situations, I can relate. And we know what it takes to make things go smoother for you. So this firm, Safe Harbor Estate Law, I started 7 years ago. I have an Avo rating of 10, 5-star Google reviews. And I'm happy to report that for the 2nd year in a row, we were just honored by the Law Firm 500. Last year, we were the 16th fastest growing law firm. And this year we dropped down to 17th, almost the same. So that to me means more and more people every year are putting their trust in us, and we're helping them and making a difference. So that's super rewarding. And you can see that I'm involved in the estate and elder bar community and keep up to date and present these issues. If you ever know a group that you think would benefit from a presentation in person or Zoom, I'd be happy to hear about that. So those are some of my credentials and where I'm coming from. Let's go over a roadmap of what we're going to do today. First of all, I'm going to tell you about the top 3 reasons why your will or no estate plan might be failing you. And then there's going to be time for questions. So feel free to jot them down or put them in the chat in the meantime. And then if you want to take what you learned today and start applying it to your life, I have some free resources that won't cost you anything, because once you hear it and you're motivated, if you're like me, it's good to start taking some steps. So we want to provide that to you. And then I have a closing story. So what's exciting to me is if you start acting on this, you're going to be moving toward getting ahead of 75% of people, because 75% of people don't have a complete updated plan. Lots of people have bits and pieces, but I want you to have a complete updated plan, because that is best. So the most common mistake is wills do not avoid probate. So people will say, I have a will, so I won't have a probate. The truth is, wills are designed to be probated. Okay. They're not always probated. There's times when you can avoid it, but there's other times people try to avoid it and it doesn't work. So don't assume that because you have a will that you're going to avoid probate. Now, probate in Minnesota right now, if you have at least $75,000 of assets passing through your will, you have an automatic probate. If you have real estate passing through your will, you have an automatic probate. If you have minor children, in many cases, there's a probate. And there's actually many other reasons, but those are some of the most common. Since most people have more than 75,000, probate is a concern. If you're wondering what probate is, it's simply the court process used to transfer the assets of a deceased person to somebody else. So you can't take it with you, right? We all know that. But when we die, we have assets in our name and in our house. How do they get to the right people? Probate is used for that. So it's either going to go by your will, what your will says, or your trust about who gets what. Or if you don't have one, a valid will in place, then the law will write in the terms for you, and the law will decide where your money goes. And that's what probate is, a process of distributing your assets after you're gone. So the pros and cons of a will. So this is a common question I get. Should I have a will or should I have a trust? So a good thing about a will is it gets the assets to the right people most of the time. Okay. The reason I have seen it not always work is sometimes if you have beneficiary designations, sometimes they're not updated. Sometimes the financial institution doesn't do them right. I've even seen a case where the beneficiary designations were perfect, but this lady had 4 daughters. She wanted the money to be divided equally between the 4, and if they died before her, to go to the grandkids of that daughter. But one daughter died before her. And the bank's policy, it was in writing, buried in the fine print. It said, if any of your beneficiaries die before you, they're zeroed out. So her daughter and her descendants didn't get anything, even though she did everything right. So we just see cases where relying on beneficiary designations doesn't always work. So generally speaking, the assets should go to the right people, but not always. And a will is less expensive now. It's simpler and it's cheaper. Cons of a will is probate is likely. If you take advantage of our offer at the end of this Life and Legacy session that's free and confidential, we can learn more about your particulars and tell you how likely it might be in your situation. Because sometimes we can tell you are absolutely going to have a probate. And occasionally we can tell you have a good chance of avoiding. And we're going to be honest. And if you hire us to do a will, we will do everything we can to minimize probate, if that makes sense. But it's pretty likely with a lot of wills. Second, probate, figure on spending $5,000 minimum, I would say. Sometimes we can do them for less, but that's kind of a good ballpark. Sometimes, especially if they're complex or people dispute things, it can be much higher, 25, 30,000, even higher. But I would just plan on at least 5. There's time-consuming hassles with probate. We hear from our clients all the time. They do not like handling the probates of their loved ones. Once in a while, there's simple ones that aren't too bad, or that people don't seem to mind too much. But for the most part, it's not people's favorite at all. They're public. So your will and your assets is going to be public information that anyone can get. And lastly, I want to talk about TODD. That's for transfer on death. If you remember, I said, if you own real estate and you have a will, you're going to have a probate. Well, one way people try to get around that, which sometimes works, is a transfer on death deed. So let's say, I would say my husband and I, when the second of us dies, the money automatically goes to our 6 children between the 2 of us. Okay. And then they would have to file death certificates. There's a little bit of paperwork, but it's fairly automatic. The reason it doesn't always work is, for instance, with 6 children, that means 6 people plus their spouses. That's currently 5 more spouses. That's 11 people who need to cooperate on, like, let's get the house cleaned out. Who are we going to list it with? What are we going to list it for? What offers are we going to accept? Everyone needs to cooperate. Doesn't always work. The other thing is, let's say my son died, me and my son died in a car accident. Well, he's got kids. They're my grandkids. I want my money to go to his grandkids. I love his wife, but I want the money to be in trust for the grandkids. And if it's tied up, any money tied up in my house, if he dies, it's going to go in his estate and it'll go to his wife. It won't go to the grandkids in trust the way I want. So a transfer and death deed is a crude instrument, and sometimes it can work, but it's not sophisticated. And to me, you might have a probate with a TOD, but even worse, your money might go to someone you don't want it to go to, and I can't fix that with any amount of money or hassle. So those are the pros and cons of wills. Sometimes they work fine. Sometimes they don't. Okay, now a trust, and I'm talking now about a living trust or a revocable trust. Pros are you should be able to avoid probate with a trust. It's one of the main pluses. It's private because you don't have probate. It's great for incapacity. If you're incapacitated, it works much better than a power of attorney. It's more flexible and it's more widely accepted by banks. The assets will go where you want because you're not relying on transfer on death deeds. You're not relying on beneficiary designations very much. So you make sure the assets are in the right place before you even go. They're already in your trust, most of the assets. So you don't have to worry about that. If you have a taxable estate, a trust can help, especially if you're married. In Minnesota, if you have over $3 million in your estate, you're subject to taxes. But if you have a special trust, the right kind of living trust that we would do, you can double that to 6 million. And that right there is really important if you're concerned about that. And of course, because the federal government, it looks like our new president is going to be Democratic. And of course, we continue to have a Democratic governor in Minnesota. There's always a chance that limit will go down. People are always concerned about changes in estate taxes. So the next pro is that there's protection from creditors, divorce, and bad financial decisions. You can have protection in there for if like you die and your spouse gets remarried to still protect your children. You can have protection for, say, like John was talking about, leaving money to nieces and nephews. If they were going through bankruptcy or a divorce or chemical dependency or things like that, or if they're young and they just aren't good at making decisions, or if they develop a special need and they're in government programs and we don't want all the money to go to the government. All of those things, there's protections and trusts for. The cons is it costs more. It takes more work to put in these special terms. And of course it costs more because it's more sophisticated. And then it takes a little more time. So whether you have a will or a trust, you're going to have a little homework after you sign the documents. And we're going to help you with that and support you with it and do our part of it. But it's important that you get your beneficiaries right and get your assets in the trust. And one difference with a trust is if you have any auto payments in your checking account, you might have to move them to a new checking account in the name of the trust. And we just want to be upfront about that. For the most part, it's way less hassle, but that upfront is a little more hassle right there. Yeah. So that's the pros and cons of the will versus the trust. So this slide, time for action, means that I have a suggestion for you. I told you if you wanted to get started on some free steps that we would help you with that. And so we have a navigation plan that we'll send you, and we give it to all our clients actually at their signing meeting. But we'll send it to you because we appreciate you taking the time to be here today. And it's about 6 pages long, double-sided, and you put things in there like who's got my healthcare directive, who to call if something happens to me, where's my important papers, who is my funeral plan with, things that would be really helpful to your loved ones. And so we recommend that you complete it and tell them where it is so they can find it, maybe make an e-copy and send it to them. So that's a recommended next step if you're concerned about making things go smoothly for your loved ones. Okay, here's a comment from a recent client. She found our smooth sailing process to be, we had friendly staff. It was thorough, easy to navigate process. And they were thinking about doing online or going with a lower cost option, but they felt like the cost and peace of mind was worth it because they know that everything is correct. And this is a family with young children. So there is an endorsement for you. The second problem I want to talk about, let's say your will is good, or your plan. You have a will or you have a trust, and we've done everything we can to avoid probate. And I alluded to this a little bit, but even if your papers are good, your assets might not go the way you want. And in order to tell this story, there should be is there? Okay. I thought there was a description. There we go. Yep, your assets may not go where you want. So I want to tell you about a story about my client, Steve. He had one brother, and his dad died. And the dad's will said, I want everything to go 50-50. And then he put one son joint on checking and one joint on savings. No, that wasn't right. He put them beneficiaries. One was the beneficiary on savings and one was on checking. And then he named one son to be the personal representative or executor in the will. Well, it wasn't my client. It wasn't Steve. It was his brother. So his brother, there was about $20,000 in the estate, and there was $10,000 of bills. So his brother paid all the bills out of the account that was going to Steve, my client. So there was no money going to Steve. And you could say, well, that wasn't right, but you'd actually have to litigate it in court. So, and I don't think that's what the father wanted. And my client, Steve, had a tough decision, and I think he made the right decision. He didn't go to court. We just put some pressure on them. We got a few $1,000s, and he's not planning to talk to his brother again. And I think the father would be very upset. And it's because he didn't have his beneficiary designations right. So one of the things we do in the smooth sailing plan is try to do everything we can to make sure you get your beneficiary designations right and your assets titled right, so that your assets don't undermine your plan. Okay, in order to, we can do the next one. This is the 4 sisters that I talked about earlier. The mom had 4 daughters, and remember, she actually had a CD from a big bank, and she said it goes to all 4 equally, and if one predeceases, then her share, her 1/4 goes to her kids. But the bank's terms on the contract for deed, that small printing no one reads, said if a beneficiary predeceased you, they're zeroed out. So none went to the kids. So actually we should have a picture, of 3 happy sisters and 1 not happy sisters. Actually, none of them were happy with the way it turned out. So those are 2 examples of how, even if your will is good, your assets may not go where you want. So in order to understand this better, I want to explain to you how assets transfer at death. First 2 ways are kind of automatic. Beneficiary designations we've talked about, like you would have on your 401k or your life insurance. On your bank accounts, they call them PODs, usually payable on death. And titling of assets. So like if you're married, you and your spouse are on the house. If one dies, the other one will own it. Fairly automatic. You have to file a death certificate and so forth, but pretty automatic. The next 2 are not so automatic. And the next 2 are probate for a will or a trust. Either way, there's going to be a person with a job to do. It's going to be a personal representative for the will or a trustee for the trust. They're going to put their hat on and they're going to transfer the assets according to what the will or trust says. So those are the 4 different ways that assets can transfer. Okay, and the next slide will show, this is what I want you to remember from those stories I'm telling. This is the takeaway. It's a surprising fact that beneficiaries and joint owners both trump the will. So you want an estate attorney who's not just going to do the documents right. They're going to take the time to look at all your assets. And we get all the statements from you, and it's not just to make busy work for you. It's because we want to make sure we know how they're titled, and we want to make sure that the beneficiary designations are correct. Because we don't want to give you a great product and then have it be undermined by your assets. So another step that you can take that wouldn't cost anything, it would be helpful to any estate planning lawyer you hired and would be helpful to your loved ones, is to complete our asset summary. This is something we complete for clients who hire us, and we'll send it to you to complete. And you can just start to gather in one place everything you own and how it's titled. A lot of times it's not titled the way we remember it. So it's good to get that in there and who the beneficiaries are so that you kind of get a picture of what your estate is. And then it's easier for everybody to take care of things if you get ill or once you pass on. So that's our second action step for you. We'll send you both by email after the meeting. And here's another estate planning client who was very pleased and said our information is understandable and helpful as we think through the details of our trust, and we were not condescending and they did not feel overwhelmed. Okay, we know this can be overwhelming, but we do our best to make it less overwhelming for you. And in our life and legacy session, we'll talk about later, we have some really good diagrams and things that you can take home and see, and that really try to lay out the process well for you. The third thing I want you to know about your will is it does nothing for incapacity. So wills don't do anything till you die. When you're alive, it's not doing anything. Like I had a friend who got a really inexpensive will done against my advice. And it came up to me one day and said, you know, my will is working really well for me. And I was like, but you're still alive. Okay, how can you tell? This is the point. They don't do anything till you're gone. You won't know there's a problem until it's too late for you to fix it. So that's why it's really important to plan ahead. And so similarly, if you lose capacity before you die, don't look at the will. It's not going to help you. Okay. There's two other documents, really three, that are real important for you to have. You probably heard of them. And I want to tell you another story about Pete, who called me. And this is close to the beginning of my firm, 6 years ago or so. And he was about 60, and so was his wife, and she had early onset. They were younger than this picture. Anyway, and he said that she had early onset dementia, and he was just brokenhearted because she had taken a turn for the worse. And she said, oh, I took her to a battery of tests last week and they confirmed this sudden downturn. Now I got to quit my job. We're going to move to my cabin. I'm going to take care of her. And the worst thing is, since she got diagnosed a year ago, I've been knowing that I need to update our estate plan, and I didn't do it. And now it might be too late. I mean, he was just so really hard on himself at that point. And I said, okay, why don't you just bring her to my office and we'll just talk, and I'll see if she has capacity to sign. And so he said, okay. Then he called back later and said, I can't bring her to your office. It was so hard for her. It was grueling going through all those doctor's tests. And I know, because I've been in there with my dad, the tests are hard. They're not easy for dementia. So I said, no, this is just a conversation. She won't even know I'm evaluating her. She will have no idea. But for me, I was worried too, honestly, because I thought, if she doesn't have capacity, we have to go to court and get a guardianship conservatorship for her. The judge is going to want me to put her on the stand. Like, how traumatic is that going to be for her? So I was very relieved. I'm very relieved to tell you that a couple of weeks later, those two were in my office signing their papers. Their one daughter that lived in town was there. I got to meet her. We got everything taken care of, and he was so relieved. And they moved up north. He took care of her. She passed on, and it all went smoothly. So the difference was, Pete made the call that was hard to make and came in when it was hard to come in. And after that, it got easier. And so the smooth sailing plan includes incapacity or, losing capacity before death planning for everybody, because everyone over 18 should have this if you have young adults. It's really important. Okay, so the first one is, the first document is a healthcare directive. And this is where you appoint people to make decisions for you, and you give direction in the decisions. So it's really important in Minnesota. And there was a tax law change, a law change in 2016. So if your doctor prescribes mental health treatments for you, even if you're getting depressed or anxious because of your condition or medications or being all locked up because of COVID, whatever, you can give your healthcare agent authority to say yes, so you can get the treatment that you need without going to court. That provision is not in any of the free healthcare directives I've seen to date, and it's been 4 years now. So this is really important to my clients, and that's the kind of thing that you want to have up to date in your healthcare directive. That's important. The next document, power of attorney. This is where you appoint people and give direction for financial and legal decisions. So again, while you're still alive, if you can't decide for yourself, or even if it's inconvenient, your power of attorney can act for you and sign things and take care of things. If you don't have it, again, the healthcare directive and power of attorney, you have to go to court. It costs thousands of dollars to get someone appointed. So I think this is really cheap insurance to have, to get what you want and avoid hassle. The third document, I think you can raise your hand or put in the chat if you ever heard of it. It's digital asset authorization. It was authorized in Minnesota when we adopted the RUFADA Act in August of 2016. And before this, the people you appoint, your personal representative, trustee, power of attorney, they didn't have any right to access your digital assets, even if they had the password. And it was a terrible situation for a family whose 18-year-old died his first semester at the U of M. And they wanted to know what happened before he died. And he was found mysteriously. He went to an ugly Christmas sweater party and celebrating the end of his first semester, left about 11, found the next day slumped over a fence by the river, frozen. I mean, horrible, horrible nightmare. Phone laying on the ground. They don't know what happened in between when he left the party and when he died. They paid for his phone. He was on their plan. They paid for his laptop. They had no rights to access any of them. Not only did they want to know who he was talking to before they died, suddenly when you lose someone, those photos, the memories, the text he sent, they're precious, precious memories. And so that family was so heartbroken. They were a big part of pushing the RUFADA Act in Minnesota. So this is really important for, kind of emotional reasons, as well as very much practical and financial reasons, that all of your people have the digital asset authorization available to them. And we do this as part of all of our plans. So not everyone's doing those. So that's something that you should look for. Here's another client that we worked for who, the mom moved up from Florida and the daughter did a lot of research and really felt welcomed here, and didn't feel like we were in a typical lawyer's office. Just makes my day hearing that. Felt like they were with friends, and we wanted to make sure you had the correct POA and trust. We were organized, fast and easy process. So we just would hope that your experience with estate planning is similar, and we'd love to do it with you, but we'd love, most important, that you would do it with somebody. To having my ducks in a row. And maybe you had your ducks in the row before, John, like we said, but yeah, you got to get them back in a row. They tend to get out of the row. So, and as we get older, we realize we're not invincible. So this is my recommendation. I already recommended those 2 things we'll send you, and those would be helpful. But a life and legacy session, I highly recommend. This would be with Dawn Thompson. And maybe Dawn could come on the camera if she can hear me. I know she's might be getting interrupted, not always here. But yeah, Dawn, you can. I don't know why I can't see her. But here's where we take the time to listen to you, to do, hi, Dawn, to do a deep, you can say hi again.
Hi.
There you go.
It's a little struggle.
So Dawn will ask about your goals and concerns, your particular situation, your finances. It's all confidential. Don't worry. It's all relevant, because then we can take that information and tell you, we'll go through that will versus trust pros and cons, and we can tell in your situation, based on what you're telling us, the pros and cons of each. And because that's the biggest decision, will versus trust. And we can explain our process, the smooth selling process, how it works, explain the costs. And again, the goal is you're educated and empowered to make the decision about what's best for you. And so then you'll know what the process is if you decide to move forward with us. So that's the life and legacy session. I recommend you do it sooner rather than later, because people tend to forget what I say in these talks, and I totally understand that. So we've just certainly gotten feedback from people that it's better to come in sooner while it's fresh in your mind. So if you go to safeharborostatelaw.com/schedule, you can schedule. if you just hang on, Dawn will talk to you, or Dawn or Gabrielle can put you on the calendar also. And we set aside some times in the next few days so that you can, to make sure there's time for you. Because again, we appreciate you being here and we want you to be able to do it while it's fresh in your mind. Yes, it's completely free and confidential. Nice. Nice. Thank you. So that is the highest value thing I offer. And then the smooth sailing story, when I was about 15, my sister, who was a year and a half older than me, and I went out in our yellow canoe. We were camping east, I think it was Lake Rebecca in Minneapolis. We had a tent trailer. We had 8 kids. My parents are the salt of the earth. I'm telling you, they took us camping. We went out in this canoe, and I had won the canoeing badge at camp one year. I mean, we felt pretty confident. And so we're heading out, and it's just a great day, and we're enjoying it. Like, let's go all the way across this big nature area lake. You know, there's no people or development there. And we get there to the end, and we're like, okay, turn around. We turn around and we realize, oh, the wind was at our back. That's why it was so fun and easy. Like, now it's hard, not to mention a storm was coming up, one of those ones that comes up fast. So the clouds were coming in. It was getting windy and dark. It was scary. I mean, I was paddling hard as I could. My muscles were tight. My chest was tight. And then I looked back at my sister, and I could tell she's scared. And because she's older than me, you know, I'm more scared. And so we're just trying to keep this thing straight. And I'm worried about dumping over because I still can't swim. And of course, I always wear a life jacket, but it's still a complete nightmare to me to be dumped in a cold lake and have to turn a canoe over. And so it was really stressful and scary. And what do families do in stressful, scary situations? Argue. Next thing we're arguing, right? So anyway, we did make it across the lake, thankfully, and we were fine. We made it to the dock, but I still remember this. How many years later? Like more 40 years later, and I learned from it though. I pay more attention to the signs, and I don't assume it's going to be as easy going back as going out. And I just plan ahead better and prepare better. So I would like for you, if you lose capacity, and for your loved ones, you know, when you pass on, to have as smooth as possible sailing, like our trip across the lake, not the trip back. And if people are on the trip back, we can help them. But I really love to prevent problems and help you have smooth sailing. So thank you for being here today, John and Michael, and anybody who watches it afterward who wasn't able to attend, that will send the copy. I really appreciate your time, and we'd love to do the life and legacy session with you. If you want to stay on right now, we can unmute you and talk to you about that.